7, Andrew Little.
Mr Speaker, my question is to the Minister of Justice and asks what factors were taken into account in setting the interest rate on legal aid debt under Regulation 14 of the Legal Services Regulations 2011 at 8%.
Honourable Judith Collins.
Mr Speaker, legal aid has always been a loan, not a grant. The charging of interest on legal aid debt was set by Cabinet in 2011 as one of several changes aimed at bringing the ballooning legal aid debt under control. This was included in the bill when it was first introduced. The regulations provide for interest to be charged at the capital charge rate, which is used by departments and Crown entities as it reflects the cost to the Crown of lending that money. Any person unable to repay their legal aid debt can apply to the Commissioner, who can write off the debt if he is satisfied that it would cause serious hardship.
Supplementary question, Andrew Little.
To the Minister, given that the purpose of the Legal Services Act is to provide, quote, legal services to people of insufficient means, how does she justify interest of 8% to the woman in Wainuiamata who has a legal aid debt incurred obtaining orders to protect herself and her children from her abusive ex-husband, and who works 30 hours a week in a low-paid job, and for whom the $75 a week extra needed to pay off the debt by March next year, or the extra needed to pay interest, will cause her serious hardship?
Honourable Judith Collins.
Mr Speaker, well, as that member well knows, that if that particular woman would like to contact the Commissioner of Legal Aid, then he will, in fact, he has already indicated that he is going to be very generous in looking at these, and the member's already stated that serious hardship, in which case she wouldn't have to repay that particular. And I'd also like to just confirm for the member, because he may not be aware, that of the $120 million a year which is spent on legal aid at the moment, only 25% of cases do not actually have to or don't have their debt waived. So in other words, only 25% of cases ever have to be repaid.
Supplementary question, Andrew Little.
Mr Speaker, what does the Minister say to the grandmother in Upper Hutt who owes over $2,000 after obtaining orders to protect her grandson, now 9 years old, and who lives on a pension and cannot afford higher payments or interest payments without facing severe hardship?
Honourable Judith Collins.
Well, Mr Speaker, I would expect that that particular person would also not be one of the people who would need to pay any interest, given one of the comments from the member seems to be that he expects that the Commissioner of Legal Aid would know the personal circumstances of all of the 60,000 people who have been written to, and frankly that's not acceptable. In fact, he's already indicated there's a 6-month period of grace for anyone to write in and explain their circumstances, and it would be waived.
Order. Supplementary question, Andrew Little.
Does she accept that people of insufficient means who use legal aid to protect themselves and children from violent and abusive situations, most of whom are women, have already done the community a favour, and charging 8% interest on any debt is just punishing them?
Honourable Judith
Well, Mr
Collins.
Speaker, I'll certainly say to that member that I believe that those women have done the community a favour in holding violent males who abuse women to account, and well done to them. Having said that, I'd say that's very unlikely that most of them would ever have to repay that debt.
Question number 8, Katrina Shanks.
Thank you, Mr Speaker. My question is to the Minister of Commerce. How will the Financial Markets Conduct Act 2013, which will be phased